The State Department recently published the October Visa Bulletin showing that India is currently oversubscribed in the unreserved EB-5 visa category. In this video, I'd like to take a few minutes to talk about what is the Visa Bulletin, what it means, highlight the differences between the unreserved EB-5 visa and the new EB-5 visa set-asides. And finally, I'd like to talk about visa retrogression and how it impacts EB-5 investors, particularly when considering taking advantage of the new concurrent filing option for eligible EB-5 investors in the United States. Hi everyone, Peter Bibler here at Behring Regional Center. For more updates like these, please subscribe to our EB-5 channel. We at Behring aim to provide EB-5 investors like you with the latest news, updates, and tutorials about the EB-5 visa program and Behring's projects. Now, the October Visa Bulletin is out, and it's already making waves among immigration lawyers, regional centers, and of course, EB-5 investors, particularly those investors born in India. This is the first Visa Bulletin for fiscal year 2023 with the new visa allocations. Now, first, we're seeing that the priority date for EB-2 visa category is reverting back to 2012 from 2014, extending the visa backlog for Indian H-1Bs in the United States. And for the EB-5 visa, China and India have retrogressed for the unreserved visa category. This applies to direct and regional center EB-5 petitions filed before the enactment of the EB-5 Reform and Integrity Act, or RIA, on March 15, 2022. For new EB-5 investors filing the I-526E petition in high unemployment, rural, or infrastructure projects remain current for all countries. EB-5 investors born in India who are already in the United States and filed I-526 petitions before the RIA, you should consult your immigration attorneys to determine if you're eligible for filing the adjustment of status application before September 30th. So what is the Visa Bulletin? The Visa Bulletin is a monthly publication issued by the State Department listing all the categories of immigrant visas and when a green card becomes available for each category. Essentially, you're checking to see if your priority date is current. And your priority date is the date listed on the I-797C Notice of Action that you received from USCIS after you filed your I-526 EB-5 petition. In short, the State Department, in conjunction with USCIS, looks at the total number of visas available for each fiscal year, then looks at the allocation of visas based on the country of origin, and then makes a projection on what the demand is going to be going forward on a per country basis and on a quarterly basis, particularly for high visa demand countries like China, India, and Vietnam. These dates can change month to month based on USCIS and State Department workloads, processing times, and policy changes, so it can be rather difficult in predicting where you are in line for the green card or when your priority date will be current. It's too early to tell how long this visa retrogression will be for pre-RIA Indian investors. There were not that many EB-5 petitions filed before November 21st, 2019, when the EB-5 modernization rule went into effect, raising investment amounts to $900,000 and $1.8 million. This was later vacated by Behring's successful lawsuit against USCIS. Far fewer petitions were filed still in 2020 and 2021. And we'll also need to see how USCIS and the State Department allocate visas between the unreserved and the new reserved EB-5 visas. As always, you should consult your immigration attorney for legal advice on your specific situation. So let's talk about the annual visa caps and the new visa set-asides. There are approximately 140,000 employment-based visas available each year, plus any carryover of unused family-based visas, which we actually saw during the COVID pandemic when U.S. consulates abroad were closed. EB-5 receives 7.1% of this amount, or for simplicity's sake, approximately 10,000 visas per fiscal year, including spouse and children. The Visa Bulletin list for EB-5 lists 4 categories. First, the unreserved visa line that includes direct and regional center for pre-RIA petitions, and the new reserved or visa set-aside lines. The RIA created 3 new visa set-asides within EB-5, reserving visas for new investors based on the type or location of the project. 1, rural, 20% or 2,000 visas. 2, high unemployment, often still referred to as targeted employment area or TEA, 10% or 1,000 visas. And 3, infrastructure, 2% or 200 visas. These visa set-aside lines remain current for all new EB-5 investors. It's important to note that the 7% visa country cap also applies to the new visa set-asides. So for the 1,000 visas reserved each year for high unemployment urban or TEA projects, only 70 visas are reserved for each country. Presumably, if the rest of the world does not have demand for the respective country quotas, the unused visas would be used by countries with higher demand. This is what we saw historically with pre-RIA with the annual 10,000 visa limit. Alternatively, the State Department could take a narrower approach. If the reserve visa lines in each category are unused, then they'll carry over to the following fiscal year in that respective category. This is described in the RIA. After the second year, any unused visas would then flow back to the general unreserved pool. If the State Department adopts this strict approach, then we could see new visa retrogression in the reserved categories later in 2023 or fiscal year 2024 when the new I-526 petitions start being approved and State Department begins to project the number of reserved visas to be used by each country, particularly China, Vietnam, and India. In this scenario, these countries would face retrogression in the reserved categories while the rest of the world would remain current. For fiscal year 2022, due to the carryover of unused family-based visas during COVID, there were an estimated 19,987 visas, of which just under 6,400, 32%, were reserved to the new visa set-aside categories. As USCIS and U.S. consulates abroad return to pre-COVID processing levels, we'll see little carryover of family-based visas. But between March 15th and September 30th, 2022, few, if any, EB-5 investors have had their I-526 EB-5 petitions approved. So these 6,400 reserve visas went unused in fiscal year 2022 and will carry over to this year in fiscal year 2023. We're monitoring to see how the State Department will be allocating these visas. To maximize visa number use, State Department, knowing that fiscal year 2022 reserve visas will remain unused for 1 to 2 years, may decide to make these available in the unreserved visa category in 2023. This could mitigate the impact visa retrogression will have on pre-RIA China and India EB-5 investors in the unreserved visa line. Again, there is no retrogression for new EB-5 investors filing petitions that qualify for the visa set-asides. In June, the State Department clarified that only new EB-5 investors filing post-RIA petitions will be eligible for these reserve visas. It's unfair to the pre-RIA investors that invested in rural or TEA projects before March 14th, but the State Department and USCIS are applying these new visa set-asides prospectively only. This means that new EB-5 investors, particularly investors from China, India, and Vietnam, are given a fresh start because all the investors that filed before the Integrity Act are now in line in the unreserved visa category. Only within the past month have we seen new EB-5 investors start to file the I-526E petitions after Behring secured a settlement with USCIS in its successful lawsuit challenging USCIS's attempt at canceling the pre-approved regional centers. See our video on the USCIS lawsuit and settlement to learn more about this. Essentially, the sooner you file, the sooner you secure your place in line for the reserved visa. A note on concurrent filing and the visa bulletin. Under the new Integrity Act, eligible EB-5 investors in the United States may file their I-485 adjustment of status application at the same time as their I-526 EB-5 petition. Filing concurrently enables you to apply for your work authorization and travel permit. If you are eligible to file your I-485 adjustment of status concurrently with your EB-5 petition, then you will not be negatively impacted if there's future retrogression because you already have your work authorization and that may continue to be renewed. See our video on the EB-5 concurrent filing strategy to learn more about this option. The key to filing your I-485 adjustment of status concurrently with your EB-5 petition is that your priority date must be current. There cannot be a retrogression for your country of origin. For EB-5 investors filing the I-526E petitions now, investing in projects eligible for the visa set-aside, such as high unemployment or TEA projects, priority dates are current for all investors from all countries, and you would be eligible to file your adjustment of status application. For pre-RIA investors that filed before March 14, 2022, you need to check the visa bulletin to see if your priority date is current for your country of origin. The October 2022 visa bulletin shows that investors from China and India face retrogression. This means that when October 2022 visa bulletin is in effect, then only those investors with priority dates prior to January 1st, 2016 for China and December 8, 2019 for India may file for adjustment of status. The October Visa Bulletin is for October. Pre-RIA Indian EB-5 investors already in the United States, especially those who filed I-526 EB-5 petitions between December 8, 2019 and March 14, 2022, you should consult your immigration attorneys now to determine if you're eligible to file your I-45 adjustment of status within the next couple weeks before retrogression takes effect. Some closing thoughts. Again, it's too early to know how long the visa retrogression will be for pre-RIA Indian investors now that USCIS has resumed processing I-526 petitions and visa petitions applications for the 2018 and 2019 EB-5 petitions from India. We'll continue to monitor the State Department's activity, particularly how it handles the reserved visas expected to be unused in fiscal years 2023 and 2024. Pre-RIA EB-5 investors from India who are already in the United States, again, should consult their attorneys to learn if they're eligible to file for adjustment of status before retrogression takes effect at the end of September. No visa retrogression exists for new EB-5 investors investing in rural, high unemployment or TEA projects or infrastructure projects. But the reserved visas are limited. If obtaining a U.S. green card is your goal, it behooves you to file sooner to secure your place in line before demand for these reserved visas exceeds the supply. This is particularly true for H-1B workers and F-1 students already in the United States who wish to take advantage of concurrent filing to obtain the benefits of a green card while they wait for the EB-5 petition's approval. EB-5 still remains a faster option than other employment-based categories such as EB-2 and EB-3. If you have questions about the Visa Bulletin, or if you'd like to learn if you're eligible to apply for the EB-5 visa and qualify for the new visa set-aside categories or concurrent filing, contact the Behring team for a free consultation. We'll provide you with the most current information about the EB-5 program, refer you to some of the attorney's top EB-5 lawyers for a preliminary consultation, and explain your investment options so that you can file a successful EB-5 petition to obtain a green card for you and your family. Thank you for watching, and we'll see you in the next video.